The litigation issues vary depending on the type of contract and the sort of the market situation. For example, as the market deteriorates right now, you're seeing a lot of litigation or potential litigation arising out of early terminations because operators want to limit their cap expense and drilling contractors want to keep revenue coming in the door. A lot of those may get negotiated, may get renegotiated to keep the contract going but reduce the rate. But there are some instances where the operator may try and terminate and the drilling contractor may sue, or the operator may take the position that the performance has been inadequate and therefore they're entitled to terminate under the contract. One of the problems with the IEDC contract is that typically there are a lot of obligations on the part of the drilling contractor, but very few remedies on the part of the operator. So it's not easy to find a warranty on the part of the drilling contractor or to find a clear right to remedy or terminate other than with the accompanying obligation to pay for the balance of the rate for the balance of the term. And in some instances, when the market is high, not only is the operator obligated to pay full rate for the balance of the term if he terminates early, but he doesn't get any credit if the drilling contractor turns right around and markets the rig to somebody else for the same period of time. Now, what happens is as the market deteriorates, those provisions get more important to the operator and a little less leverage for the drilling contractor. You also see a good bit of litigation about the risk allocation provisions. Indemnities, the courts assume that indemnities are intended not to cover your own fault unless you say so. So the test from various jurisdictions is that you've got to be clear, and in some instances, like Texas, you have to be express. So when an accident happens, these risk-shifting provisions all of a sudden become very critical and very expensive, and so you do have a good bit of litigation about whether the indemnity obligation is enforceable, whether an anti-indemnity statute applies, what law applies is a big issue as to whether or not an offshore drilling rig is considered a vessel, so therefore an offshore drilling rig is a maritime contract. But for the people who work on it, the well service contractors, they may not be maritime contracts. They may be governed by state law and therefore covered by anti-indemnity statutes that prohibit or curtail the indemnity. There's a lot of litigation about insurance because it becomes critical to be able to insure these risks.